My name is Bernie Krooks, and I'm happy to be here. I want to thank Bert for inviting me. I am the founding partner of a law firm called Krooks, and we have offices in White Plains. You can't hear me? Okay. We have offices in White Plains and in New York City. And our law firm specializes in helping seniors deal with legal issues of aging, getting older, and what you need to do about it. And what we help people with ranges from how to make a decision about who's going to take care of your affairs when you can't take care of them anymore, what's going to happen to you when you pass away, and who's going to get your assets, how are you going to set up your affairs so that if you or a loved one needs long-term care in a nursing home, who's going to make sure that those assets continue on for your spouse and children to make sure that they don't get spent on the cost of your care. So it's a whole range of issues that we focus on at Krooks. We work with people, okay, in this type of situation. We recommend 4 documents that everybody have, and those are the tools of the trade of an elder law attorney. Let me tell you what they are. It's a durable power of attorney, a health care proxy, a living will, and a last will and testament. Everybody in this room and everybody's family of members in this room ought to have those 4 documents, okay? Healthcare proxy, living will, durable power of attorney, and a last will and testament. It's called the Fab Four. Those of you may remember the Beatles. This is Bernie's Fab Four, those 4 documents. I want to tell you what each one of them are, and I'll feel satisfied that if at least one of you in this room goes out and takes care of one of these things in the next few weeks, I'll feel like I accomplished something, because I've been practicing elder law and estate planning for 21 years now. And one of the most frustrating things to me as a lawyer is how little attention people devote to these very, very important issues. I find that clients spend more time deciding what color carpet they're going to put in the living room, what kind of car they're going to buy, where they're going to go on vacation, and all of these things are, they're important to most people, but they're not as important to figuring out what you're going to do with your finances and how you're going to manage your affairs at the end of life. I mean, because that is something truly that every single one of us is going to have to deal with. I can say without exception, everybody in this room is going to have to deal with the issues that I'm going to talk to you about today. So you can avoid it and put it off until it's too late, and then get involved in some complicated court proceedings at great expense and inconvenience to you and your family. You can still do that. Or you can plan in advance and take care of these things before it's too late. And that's what I'm here to tell you about today. And that's what the 4 documents are about. All right, so let's start with the first one. It's called a durable power of attorney. It's called a durable power of attorney because it survives your incapacity. So if you sign it today when you're feeling fine, and then tomorrow or next week or next year you're not feeling okay, the power of attorney who you appoint will still be able to act on your behalf, okay? The power of attorney, sometimes people call it an agent. If I appoint you to go to the bank and write a check for me, you're my agent. So you may hear people refer to it as that. It doesn't take away your power to manage your own affairs right now. So as long as you're perfectly okay and willing and able to manage your own affairs, the power of attorney simply is a document that's sitting in your drawer that's not going to have any legal effect until you can't take care of your own affairs yourself. Now think about this. If you don't appoint somebody as your agent, and you become incapacitated and you can't manage your own affairs, and that could happen. In fact, according to the latest statistics from the National Association of Insurance Commissioners, over half of us are going to spend some time in a nursing home and be incapacitated, not be able to take care of our affairs, either physically or mentally. We're just not going to be able to pay the rent, we're not going to be able to pay the mortgage, we're not going to be able to pay the electric bill, we're not going to be able to pay the heating bill. Things are going to happen so that we're not going to be able to take care of ourselves. And when I always say it's going to be half of us, everyone says, well, those are pretty good odds, and look at the person to the left, say, oh, it's going to be him, it's not going to be me, it's going to be you, it's not going to be her. But the truth is, you really don't know who it's going to be. And if you wait until you find out whether or not it's you, it's going to be too late. So you appoint somebody as your agent under this power of attorney who is going to pay your bills for you in the event you get sick. You still pay them while you're fine, but if something happens to you, this person steps into your shoes to take over. Now, if you don't sign this power of attorney, and you say, you know something, I want to roll the dice and I want to take a chance here and see if maybe I'm going to be in the half who just dies in my sleep one day and I'm perfectly healthy. Well, if you're wrong, then your family's going to have to go to court to get a guardian appointed for you. They got to go down to White Plains, or there's a court up in Putnam County, depending upon where you live. And it's a very time-consuming, expensive, and invasive process. What happens is all of your family's history and financial matters and personal relationships has to be discussed in front of a judge. The court appoints someone to investigate your family, to look into your finances, to see what's going on. And then after they have a hearing in open court where other people can sit in and listen to your affairs, there's a hearing in open court, somebody will be appointed as your legal guardian. Now, if you're lucky, it'll be somebody in your family. If you're not, it'll be somebody appointed by the court. And it's going to cost thousands and thousands of dollars, and it's going to require your family to report to the court on an annual basis. They're going to have to show all the expenses, show all the interest income that you have, and someone from the court is going to have to review it, and it's going to be very, very burdensome for you. It can be avoided by having this durable power of attorney. Now, for lots of reasons, people don't sign these powers of attorney. One reason is they say, well, I don't know who to appoint as my agent, as my power of attorney. I've got 3 kids and I don't know who to appoint. So they become like a deer in the headlights and nothing happens because they don't know who to pick. Well, you can pick one of them. Let's say you have a child who lives close by and the other 2 kids live out of town, or you can pick the one who you think has the most financial sophistication. Somebody might be a banker and somebody else might be in a different industry where they aren't used to working with numbers. So you can pick whoever you want. You have 3 kids, you can pick one of them, or better yet, if you want, you can pick all 3. So if you have more than one child, or you have more than one relative, and it doesn't have to be a child, it doesn't have to be a relative, it can be a friend, it can be your accountant, it can be an acquaintance, it can be anybody you want, okay? It just has to be a human being. You can pick whoever you want, and you can pick as many people as you want. Now, it doesn't make sense to have 12 powers of attorney. I mean, let's be real. I think probably the most we've had is a gentleman with 5 kids, and he wanted all of them to be on the power of attorney. He didn't want to slight anybody. So we're able to accommodate him. There's plenty of room to do that. Now, once you pick more than one person, you've got another decision to make. So you have a son and a daughter, and you want to pick them both as power of attorney. Well, do all decisions have to be made unanimously? Or does either one of them have the authority to bind you, to write a check, to go to the bank and take money out? You need to make that decision. Now, there's pros and cons of doing it both ways. If you have 2 people as power of attorney and you require both signatures, and one of them is out of town or is unable to sign, or for whatever reason is unavailable, and something needs to get done, well, if you're requiring 2 signatures, then you're not going to get it done until the other person is available. So it may handcuff the agents at a time when they actually need to act on your behalf. A benefit of having 2 signatures is if you're uncomfortable giving somebody so much power where they can go to the bank and take out money on your account and write checks, or sometimes it's not about whether or not you trust the person. Let's say the brother and sister don't get along, your 2 kids, and they don't trust each other. So they're more comfortable being involved on a basis where joint consent is required. So some people like to know that 2 signatures are required. We find that about 3/4 of the clients choose to have each agent under the power of attorney act independently so that only one signature is required. Because if you really trust the kids and you don't want to handcuff them, it doesn't matter whether it's the son or the daughter who signs. Just pick, pick the one who's readily accessible on the date that the check needs to be signed, and that makes life a lot easier for people. Now, one of the things people forget about with the power of attorney is it dies when you die. So if you have a power of attorney and you pass away, the person who you appoint under your power of attorney has no authority to act on your behalf. The only one who can act on your behalf when you pass away is the legal representative of your estate. You've probably heard the term executor. An executor is what happens when you die with a will. If you die with a will, you have the right to appoint in your will who you want to be, in effect, your power of attorney when you die, who you want to be your executor. Okay? This person has the responsibility of marshaling all your assets, getting them all together in one place, and then selling whatever assets are necessary in order to pay all your debts and any bills that you may have, and then distributing the assets to the people who you want the assets distributed to. You get to pick who gets your property. Now, in New York State, we don't have forced heirship. So if you have 2 children and you want to leave your property to one of them, you can leave it to one, and as long as when you made out your will, you are of sound mind, the other child can contest it, because I can never tell you that he's never going to contest it, because you can always contest something, but they wouldn't win. They would file papers and the judge would dismiss it, because as long as you have sound mind, you have the right to dispose of your property as you please in New York State. The only one who has a right of heirship in New York State is a spouse. So if you're married, and this is interesting because most people think that if you're married, the spouse gets to inherit everything. That's not true. In New York State, if you're married, your spouse has the right to 1/3 of your estate. So if you have $300,000 and you decide to, and you're married, and you decide to leave the $300,000 to your child, and you die, your spouse would have the ability to file papers with the probate court in Westchester County. It's called a surrogate court in Westchester County, with the surrogate's court saying, hey, wait a second, I'm entitled to my 1/3. And the spouse would be entitled to 1/3 of $300,000 or $100,000. Other than the spouse, you have no legal obligation to leave your property to anybody. You can leave it all to charity, you can leave it all to a child, you can leave it to a friend, you can leave it to whoever you want. It's completely up to you. Now that's if you die with a will. If you die without a will, then New York State has a will for you, because we're not going to let you die without a will. So we decide who gets your property. It's called, you may have heard the term, it's called intestacy. So if you have somebody dying intestate, that means they died without a will. And what happens is, we've decided that if you die without a will, your spouse is going to get half your property and the kids are going to get the rest. If you die without a spouse, it's going to go to the kids. If you die without kids, it's going to go to the parents. So there's a whole listing of people. There's a hierarchy in the statute telling you who's going to get your property if you die without a will. Now, you may read that statute and say, you know something? I like who New York State has decided is going to get my property if I die without a will. But you may not like it, and that's the point. Most people don't like the will that New York State makes for them, so they make their own will. The other thing is, New York State will decide who becomes your executor. Now, they don't call it an executor. When you die without a will, they call it an administrator. But the judge and the state will decide who is going to be responsible for marshaling your assets, who's going to be responsible for paying your bills and distributing your assets. If you want to have control over that, it's very simple. You make a will. Now, a lot of times people don't make a will because they say, you know something, I'm not sure what I want to do. One of my kids is a teacher, married to somebody in the Peace Corps. They're not making a lot of money. The other one's a famous surgeon. He's making a lot of money. He's married to a high-powered lawyer, and they're doing very well. And if I leave half my estate to each one, then is it really fair because the other ones aren't making as much money? Then you get another person who says, well, I want to leave it 50-50 no matter what profession the kids have chosen. There's no right answer. And lawyers have a saying, what's equal isn't fair and what's fair isn't equal. So you don't know, okay? There's no right answer, there's no wrong answer here. It's whatever you're comfortable with. But if you don't make out a will, then the government's going to decide who gets the property. So a lot of benefits to having a will, and to simply say you don't want to do it because you're not sure of what you want to do doesn't make sense. Make a decision, and if you don't like it, tomorrow you make another one. You don't like that one, next week you make another one. Wills are what's called ambulatory. They don't take effect until you die. So if you make a will today and 6 months go by and you decide, you know something, I didn't get a card for Father's Day for my son, and the other one always, it happens. I got to tell you, as a lawyer for 21 years now, it's really a disgrace what has happened to the American family. I can't remember the last time I met with clients where there wasn't something going on. This sister-in-law didn't talk to that one, or this one wasn't upset they didn't get invited to that, or Thanksgiving dinner. There's always something, and these are deep-rooted issues in families. So the last chance you have to express your wishes is in your last will and testament, and we see a lot of people putting in language in their wills saying, listen, you know that time you didn't do that? I was really upset about it, so therefore, instead of getting X, you're going to get Y. So if that stuff is...
Put that in the will?
Yes, you can put that in the will.
Yeah, but people do.
People do put it in the will. In fact, many lawyers say it's important to give you a reason. So if you have 3 kids and you're not going to leave it a third, many lawyers will say, put a reason in so that the child who's getting shortchanged, if you will, maybe won't even contest it because they'll have a better understanding of why you did what you did. Others say you're better off not putting anything in because you don't want to put lighter fluid on a already dicey situation. So again, it depends on which lawyer you're working with and what they're comfortable with. So this will can be changed as many times as you want, and what happens is when you die, the will gets admitted to probate. Now, many of you have probably heard the term probate, but maybe you haven't thought about what it means. Probate is a Latin term. It means to prove. So when you die, the only person in the world who knows that this is your last will, that you didn't make another one, is you, but you're dead. So we can't ask you. So if you had a will dated June 6, 2006, and you died on June 8th, 2006, how would we know you didn't make another will on June 7th? Nobody would know but you, because you could have gone to another lawyer, you could not have, maybe you didn't tell your wife about it, or whatever. You could have done it. So since we don't know whether or not you did it, and we can't ask you, then whoever has a will that they think is your last will, whoever's got that June 6th will, they go and hire a lawyer and file it with the court. They say, okay, we think this is Charlie's last will. And then you give notice to certain family members, and the law tells you who you got to give notice to, and they get a copy of the will. And they say, listen, Aunt Sally thinks that this is Charlie's last will, that he hasn't made a later will. If you know of a later will, or if you know of any reason why this will shouldn't be admitted to probate. Well, because Charlie had end-stage Alzheimer's at the time he made it and he wasn't competent to make out a new will, that might be a reason. Or he was in a coma. I mean, so there are lots of reasons he wasn't in his right mind. So if you have a reason why we shouldn't admit this will to probate, or if you think there's a later will and you know where it is, come forth and tell us about it. And you get a few weeks to appear in front of a court and tell the judge your story. If nobody appears, then the last will that was submitted for probate is admitted to probate, and the assets are then marshaled and distributed to the heirs. Now, a lot of people ask, what does it cost to probate a will? A lot of people don't want to do wills because they're afraid of the cost of probate. I will tell you categorically, it costs more money to administer an estate when you die without a will than when you die with a will. Because what happens is the lawyers and the family members spend more time trying to gather information and organizing your affairs, and this time could have been spent on actually doing the probate work. So if you want to save your estate money, have a will. If you're concerned about the costs of probate, talk to your lawyer before you hire the lawyer. Find out what the fees are in advance. Most lawyers, if they can, will try to give you a flat fee to do the work. If there are contingencies beyond their control, they'll tell you what they are, and maybe they can give you a range of what it's going to cost. If you're not happy with the legal fee arrangement, talk to another lawyer. I mean, these things ought to be discussed up front. If you want quality representation, it's going to cost money. If you want to have a lawyer who does a little bit of the probate work, does a little bit of the real estate work, does a little bit of patent work, does a little matrimony work, okay, that's something to take into account in terms of how much of a specialist do you want to handle your affairs and how important is it to you. And that goes back to the original comment they made. Most people view this as something that's just a nuisance, that they don't want to have to go through. But the truth is, every one of us in this room is going to have to deal with these issues. So that's what happens if you don't have a power of attorney. Even if you do have a power of attorney, you still need to have a will because you don't want to have to go through this intestacy proceeding in New York State. And the executor in your will is like your power of attorney. It's just that's the person who takes over after you pass away. Doesn't have to be the same person. The person who you appoint as power of attorney can be a different person than who you appoint as your executor. It's completely up to you. Next document is a healthcare proxy. This is like a power of attorney, except instead of it applying to financial matters, remember the power of attorney applies to bank accounts, credit card debt, asset transfers, all kinds of financial matters, real estate. The healthcare proxy has to do with making medical decisions. Now, we have an interesting law in New York State. Anybody who's a competent adult over the age of 18 years old and who has their right mind is able to make their own medical decisions. So you talk to your doctor, the doctor makes a recommendation, and ultimately at the end of the day, you decide whether or not you want to accept that treatment. You don't want to do it, nobody can force you. If you do, you go ahead and have the procedure. If you're not competent, you can't make these decisions because you are suffering from dementia, and there are various levels of dementia. Many people with mild or middle stage dementia are able to make these decisions. Many are not. It really depends on the situation. And this is really a gray area. Lots of times, I'll forget where my car keys are. Does that mean I'm not competent? No. Maybe I'll forget somebody's phone number. So, this is really a gray area. But if it's determined that you're not capable of making your own decisions, and by the way, competency is not a politically correct term in New York State anymore. The correct term is capacity. So if you have capacity, you're able to make legal decisions. If you have diminished capacity, you may not be able to make these legal decisions, such as your health care. So the proper term is diminished capacity. So if you have diminished capacity and you don't have a health care proxy, so you don't have legal capacity and you don't have a health care proxy, then I bet you've heard of the Terry Schiavo case from last year in Florida. Okay, so this is a perfect example of how this doesn't only apply to seniors or elders. This is an example of how you can be a perfectly healthy 25-year-old woman and have a heart condition and all of a sudden go into a coma for 13 or 14 years, and then your husband and your parents are fighting in court at a seven-figure legal fee, and you're in the newspapers, and they were just a regular old family. And the reason they were in the papers and the reason they spent all this money was because they didn't have a health care proxy or a living will. We'll get to a living will in a second. If she had a health care proxy, that whole thing could have been avoided. And you can't turn back the clock. God doesn't call you up and say, you know something, Jack, 2 weeks you're going to have a stroke, so you better get that health care proxy done. If you don't do it today, I can't promise you you're not going to be the next Terry Schiavo, because we currently have 5, and this is just in Westchester County, we have 5 Terry Schiavo cases where families are fighting. People, relatives are wasting away 60 pounds, 80 pounds, 40 pounds. One person's 40 pounds, okay? Wasting away, and the family is fighting over whether or not they should be kept alive or not. These aren't in the papers, okay? They all don't make the papers, but they're happening right here. And you can save your family this stress and this disgrace by simply having a written document called a health care proxy. You really don't even need to go to a lawyer. You can probably pick up one here. You can go to your doctor and get one. You get one at any hospital. All you need is 2 adults to be witnesses. Now, the adults can't be the family members who you select to make the decisions for you. So you want to pick somebody who's going to make medical decisions for you, and they're only going to make these decisions when you can't make them yourself. So you're not giving anything up. You talk to your doctor, you make the decision. The healthcare proxy only makes the decisions for you when you can't make them yourself. Now, the difference between a healthcare proxy and a power of attorney, or one of the differences, is they got to pick one person. They didn't want to put the medical profession or the healthcare providers in the position of having to talk to 2 people, and the son says, well, mom wouldn't want to live under these conditions, let's pull the plug, and the daughter says, no, mom wants to be kept alive, and the doctor doesn't know what to do. So they make you pick one person who is the spokesperson. Now, the family can have a meeting, they can talk together, they can all make the decision so that they all feel like they're on board and part of the process, but at the end of the day, there's got to be one agent, one spokesperson who's going to communicate your wishes to the doctor or to whoever is providing the health care to you. Without a health care proxy in New York State, and a relative does not have the authority to make non-routine, non-emergency medical decisions for you. We are one of a couple of states in the country that does not have surrogate decision-making. Surrogate decision-making means, remember I said that if you die without a will, New York State will make a will for you. They'll tell you who's going to get your property. Well, if you get sick without a health care proxy, we don't have a law that says, okay, if you don't have a health care proxy, then your wife makes a decision, and then your kids, and then your nephews, and then your uncle. We don't have one of those statutes. Our statute says if you don't have a health care proxy, then your family has to go to court to make these medical decisions for you. Again, this is very expensive, and it's time-consuming, and it's an invasion of privacy. For the last 10 years or so, we have had a bill proposed in the New York State Legislature which would have passed surrogate decision-making authority, so it would have allowed your loved ones to make decisions for you without a healthcare proxy. Now, even if that passes, you may not like the statute. You may not like who they pick. But it hasn't passed for the following reason. There's been opposition from several of the special interest groups. One of them happens to be the same-sex marriage group. They're saying, well, if you're going to give a wife the right to make a medical decision for a husband, then a same-sex partner ought to have the right to make a medical decision for a same-sex partner. And that has been holding it up because they have not been able to push that through the New York State Legislature. There are a couple other special interest groups that are also holding it up, and they won't just pass the statute as it is and then deal with these other issues later on. They want to pass what they think is a complete bill so that they include everybody. So, I mean, I'm not going to get into the political issue of the same-sex marriage, but that's what's holding this up in New York State. So until we have that, you can't make medical decisions for loved ones, non-routine, non-emergency medical decisions without this healthcare proxy. Now, a healthcare proxy is different from a living will. A living will is a written expression of your wishes and desires in the event you become permanently incapacitated in a vegetative state. You're in a coma, and you're not going to get better. The only question is, you're going to die, but the question is when. And it could be a year, it could be 2 years, it could be whenever, but modern medicine can only do so much and you can't get better. It's not like you have a heart attack and you may be incapacitated for a couple of weeks or months, but you can get better. If you're in a coma or in a persistent vegetative state and the doctors conclude you cannot get better, as was the case with Terry Schiavo, then a living will would say, I don't want to be treated medically. I simply want medication for pain so that I'm comfortable and I don't want to be treated to try and get better. So a living will applies when you're in that state. A healthcare proxy could apply to anybody. It could apply to a 25-year-old kid who's driving on the Taconic State Parkway, gets into an accident, is unconscious for a couple hours, and somebody needs to make a medical decision for him. So he's not terminal, but he can't make a decision. So a healthcare proxy is critically important in that case as well. All right, so those are your 4 documents: your healthcare proxy, your living will, your last will and testament, and the durable power of attorney.